Hi, my name is Darius Amiri. I am an attorney and the chair of the Immigration Department at Rose Law Group PC, a Scottsdale-based law firm, and I'm here today to talk about the Supreme Court's decision this morning not to take up a challenge brought by the Trump administration regarding California's so-called sanctuary cities law. So a little bit of background on the term sanctuary cities. I personally believe that is a broad and often misused term that's kind of intended to rattle people up or scare people about this idea of liberal or left-leaning states passing all kinds of laws to encourage or to incentivize illegal immigration. And that's just not the case. Sanctuary laws, what it really comes down to is the interplay between state and federal rights. So immigration enforcement is a federal responsibility. We have agencies like ICE, which is Immigration, Customs, and Enforcement, which fall under the purview of the Department of Homeland Security. And these agencies are tasked with the identification, location, detention, and sometimes deportation of foreign nationals who are in the United States who have violated their immigration status for some reason or another. Now, what California did when it passed SB 54 was to prohibit California law enforcement or California state actors from cooperating with or essentially doing the job of ICE in identifying or reporting on the nationality or the immigration status of people who may have come before state attention, essentially saying, we're not going to do the job of the federal government here. That's going to be the federal government's job, and we're going to stay out of that. That's perfectly within their right to do so, but the Trump administration had other thoughts and brought a court challenge. And in the court challenge, it was the position of California state lawmakers that it was not their intention to create some kind of a haven for illegal immigration or to kind of incentivize people to break federal law but do it under the safety or the sanctuary of California, but rather that they were going to ensure that they focused their efforts, their limited resources on safe communities, on communication between communities, on the limited amount of resources that they had applied in the area where they felt it was best needed, whereas the federal government is there to enforce federal law. And that's really all it boiled down to. So the Ninth Circuit agreed with California and held that that SB 54 was an issue that was allotted to the states. The states were allowed to legislate whether they were going to join in or assist with federal duties, and it was within their right to not do so. And the Supreme Court today declined to take the case any further, leaving the lower court's ruling in place, which I believe is a good ruling. At the end of the day, this whole notion of federalism is that any power not delegated to the federal government is therefore left to the states wanting to pass laws on how, to what extent they want to be involved in areas like immigration. It's their right to do so, and it's not incentivizing illegal immigration, but rather just allocating resources in the way each state seems fit. So I think that was a good decision by the Supreme Court today. We've got our eyes on potentially much bigger decisions, such as the DACA decision, which could come down as early as this Thursday. And so we'll be keeping our attention there and providing updates as more comes out. Thank you very much for your time. Be safe. Bye-bye.